Well, we've had our fair share of icy and snowy weather here in West Michigan, which of course leads to numerous slips and falls. And what happens if, God forbid, you slip and fall on someone else's property? What rights do you have? Well, recently the Michigan Supreme Court heard argument on premises liability law. And there may be some changes coming there. For that, we take a dive in with Tom Sinas from Sinas James Law Firm. Hi, Tom.
Hey, Todd. How are you?
I'm well. I got to be honest, I don't know a lot about premises liability law. Can you break that down for me?
I sure can. It is kind of a funny phrase. It's only ones that lawyers and judges would use. Most people might use the term slip and fall, but the scope of what we're talking about here is often broader than just slipping. So we're talking here about situations where a property owner owes a certain, what we call legal duty. When do they owe that legal duty and to whom? And the general concept here is that if you're a property owner and you invite people onto your property, whether you're inviting them over for a party or assuming they're going to come up your front steps to deliver the mail or a package, then you as the property owner, under what we call the common law, the general law of our cases, you as the property owner owe a duty to make sure that that person is not exposed to unreasonable dangers. You owe a duty of what we call reasonable care. And in situations where someone is injured on someone else's property, the question then becomes whether or not the property owner, who may have owed that person a legal duty, has breached that legal duty and resulted in the person sustaining an injury. So that's the general concept here, what we're talking about when we use that term premises liability.
So is this law a federal law the same across the country, or is Michigan's law different than other states?
This is a state by state law. So Michigan has its own law and has its own very unique law. About 20 years ago, the Michigan Supreme Court issued a decision that announced a rule that's been referred to over the last few decades by its shorthand name, the open and obvious doctrine. And what this said was that even though we have these general duties, as I mentioned, that a landowner is not required to protect an invitee from open and obvious dangers. So what that means, and what that has meant, is that courts have been looking at scenarios where people are hurt, and they've been asking, well, is the thing that the person injured themselves on, is that, quote, open and obvious by an observer upon casual inspection, as the phrase is used? And if it was, then the landowner is absolved completely from liability. And many people have criticized this law over the years. And one of the criticisms you hear is that, well, this has a way of allowing landowners to get away with more and more dangerous conditions on their land, because the more dangerous something becomes, the more open and obvious it becomes. But yet, if it's open and obvious, the landowner has no liability. And of course, in these cases where people are hurt, it almost is always the case that whatever hurt that person wasn't open and obvious to that person, or they wouldn't have been hurt by it. So there has been a lot of discussion by legal commentators over the years about whether or not this open and obvious doctrine is correct, whether it's fair, whether it's consistent with other principles of Michigan law. So it's really that doctrine that the Supreme Court, as you mentioned in your lead-in, heard oral arguments in earlier this month. And of course, we don't know how the court's going to rule, but we may see some changes here in how we're applying these rules to what we call the law of premises liability.
Sounds like there's a lot of, well, gray area there that they got to work out. So in the meantime, what should, well, property owners, homeowners like ourselves be doing just to protect ourselves?
Well, I like to think of it not as a lawyer, but as a neighbor, as a friend. You should do the neighborly thing of keeping your property in a reasonably safe condition so that people who come onto the property aren't hurt, right? Because regardless of our legal liability, what it may be today, what it may be in the future, no one wants to be in the situation where someone's been hurt on someone else's property. That doesn't mean that your property has to be perfect in all senses, but if there are things that you as a property owner can do, things that you're aware of, particular, if you're aware of a condition on your property that may expose someone else to injury, don't ignore it. Address it reasonably so that hopefully you never have to worry about what is the law of premises liability in Michigan, because you'll be in a situation where people are coming and going freely from your house and nobody's getting hurt.
Well, unfortunately, I'm sure there are some out there even today who are dealing with that exact situation. And if they need to know the specifics of their case and maybe they have some questions, how can they get a hold of you?
Well, they can find our firm online at www.sinusdramus.com. They can shoot us an email at info@sinusdramus.com or give us a call in West Michigan at 616-301-3333.